Next case to come before the court is the Estate of Dewey A. Jones III through Executor Lynn versus the State of Ohio. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of time. Hopefully also you will be able to see your time on the screen. Sometimes that goes awry though, so that's why we ask that you let me know. The arguments are being recorded, so please keep your voices up and remain behind the podium. You should not use the names of children or minors or victims should that be involved in your argument. You can refer to those folks as initials or with general terms. I don't think that is really relevant here, but the judges have read your briefs and they're ready to proceed when you are. And I would just ask the appellant, would you like to reserve time?
Yes, I'd like to reserve 3 minutes, please.
Very well, then you may proceed when you are ready.
Thank you, Your Honors. May it please the Court. My name is Michelle Berry, and I represent the estate of Dewey Jones through its executor, Lynn, who joins us here today. She'll be stepping in, and a couple of Dewey Jones' children are here as well. Your Honors, this case is about the legacy of Dewey Jones. Dewey Jones spent nearly 30 years of his life fighting the system to clear his name as a murderer, 20 years in prison, sitting innocent for a murder he didn't commit, and another 7 years fighting to clear his name. The state finally conceded that he was innocent and agreed in writing to a settlement to clear his name with a declaration of innocence, something that was priceless to him and his family, not just during his life, but for all time, as well as a specific sum of money. All of this occurred with Dewey Jones 1 month before he died. Dewey Jones then died in February of 2021. The state then conceded that his claim survived his death and agreed to execute the settlement despite his death. The parties proceeded to do just that. After Dewey's death, the state, along with counsel for Dewey Jones, drafted, signed, and filed the Declaration of Innocence with the court, which the court then entered in March of 2021. More than 6 months later, and nearly a year after the settlement was entered, different attorneys within the Attorney General's office decided they would have handled the case differently, interpreted the law differently, and requested the trial court to vacate that Declaration of Innocence, which the court did. What is important here is that this case is still settled. It still remains settled in black and white according to the January 20th, 21 entry that's still on the books. This is document number 17 in the record. And the settlement is still in place. That is now the final entry in the case. And what sets this case apart from the others that the state will likely talk about today, Murray and Rogers-Henderson and cases like that, is that this case was entirely resolved during Dewey Jones' lifetime. It was settled during his lifetime and in all aspects. There's 2 parts of the settlement, and both of those were entirely resolved. And that is why the case is entered as settled and dismissed. So this turns on the fruits of the settlement, that his heirs are entitled to inherit according to the plain language of the statute, which I'll discuss briefly because I think that's covered pretty extensively in the briefs, but I would like to touch on that, as well as common law treatment of this type of claim.
I have a question about jurisdiction. So the common pleas court had jurisdiction to do the declaration of innocence, but not any monetary settlement would be through the court of claims, correct? Am I right on that?
Right, the Court of Claims is in charge of dispersing the money, but what happened in this case and was not novel, has happened in other cases and happens quite frequently, is this case resulted in a global settlement of both parts of the lawsuit. Part 1 is, of course, the common pleas phase. Part 2 is the Court of Claims phase. But all of the issues were resolved in the global settlement, which was for the Declaration of Innocence, and the sum of money was actually already determined. So in the end, once the Declaration of Innocence was issued, that's essentially the ticket to get into the Court of Claims,
Right.
and The settlement papers needed in the Court of Claims actually were already completed as well. It was simply a matter of procedure because that's how the Office of Budget and Management works. They have to get an official entry from the Court of Claims and so forth.
So would the common pleas court have jurisdiction then to enforce a monetary settlement in this case?
What they do have jurisdiction to enforce is putting the Declaration of Innocence back in place. And as far as the settlement, which was for both issues, the settlement actually is still in place. It's just the fact that the part that was executed was rescinded, and that's the part that the trial court did and still would have jurisdiction to put back in place. And then as far as the monetary, as far as enforcement of the monetary award, once that Declaration of Innocence is back in place, the estate then has standing to receive that monetary sum. And that's according to the plain language of 2743.48. And that's one of the points I wanted to talk about today, is the General Assembly is very intentional with how they use the words individual and person in the relevant statutes. Individual is very distinctly used discussing the wrongful conviction itself, the elements that the individual has to satisfy and go through to be wrongfully imprisoned. Once the individual, and it's undisputed that that has to be an individual, and it's undisputed that according to 2305.02, an individual has to commence that lawsuit and satisfy those elements. But once that occurs, the plain language states that a person, and the revised code defines person to include an estate, may commence the lawsuit in the Court of Claims. And that's exactly the situation we have here. The individual, Dewey Jones, was alive and well through every part of this case, settled it with the state, and actually had the entry from the trial court saying settled and dismissed. And in fact, if it weren't for the state's need for continuances, the Declaration of Innocence likely would have been entered in February 18th or 19th, days before he actually passed away. But, you know, as noted in the brief, the state became unresponsive, so it ended up happening after he died. But to get back to the point, the trial court does have jurisdiction to put that Declaration of Innocence back in place, and the case still remains settled. That's how it stands on the record. And what's another important thing to note is the cases that the state will likely point to, Murray and Rogers-Henderson, and any other case, because they don't exist, frankly, there isn't any other case where the case was entirely settled, and then someone passed away, and it's purely about the heirs receiving the fruits of that settlement. In fact, the Ohio Supreme Court has addressed an analogous situation, Whetstone v. Benner, in 2016, where the court decided that the hearing for punitive damages could go forward after the tortfeasor had passed away, even though a claim like that typically may abate at death and typically has been treated to abate at death. And what the court pointed to as a significant fact was that the claim was entirely resolved while the parties were alive. The liability was determined, and it was purely a matter of determining these damages and allowing the plaintiff to receive the fruits of the benefit of having that liability determination, the fruits of the resolved case. And that's exactly the situation we have here. Only this case is stronger than Whetstone because the dissent in that Whetstone case, Judge Lansinger, not you, the retired justice, was concerned that it didn't make sense as a policy to allow punitive damages to go forward when the tortfeasor's dead, because of course that's supposed to punish the bad actor. So that was Judge Lansinger's concern in that case. But that's a non-issue here, because this case is about the legacy of Dewey Jones, his name being cleared, and that's arguably more important after you're gone, the legacy of having your name cleared for your children and your heirs, when you can no longer be here to tell your own case and tell your story, that holds value for all time. And that's something that his heirs had stripped from them 1 month after their father died. And of course, the money, that's something that heirs would stand to inherit in any event. So those policy concerns that were brought up in the Binner case are not an issue, and actually counsel in favor of the estate's case here. Speaking of the cases, one thing I wanted to discuss today is how a case from this district, actually, the Witcher v. Fairlawn case, that the trial court actually referenced in its opinion, has led the courts astray by a simple error, by a clear error in how the cases cited in that case have been interpreted. Actually, not even interpreted, it's just a plain error. So if you look at the history of how the common law in Ohio treats cases like this, there is a history starting in 1929 with the case Mouse v. Central Savings and Trust. It's an Ohio Supreme Court case from 1929, where the court treats a wrongful imprisonment claim as an emotional distress issue, as an emotional distress claim. This district did the same thing in Morgan v. B.F. Goodrich in 1937, and it's a very important term started being used, the term personal rights. This court also treated a wrongful imprisonment claim as emotional distress and went on to say that that's an invasion of personal rights. And that phrase started being used. It was used again in O'Neill versus State in 1984 in the 10th District. It was used again in 1988 in Jones v. Department of Highway, and Krabs v. Scott, even a Sixth Circuit case. The Judge Sutton, different Judge Sutton, again, talks specifically and says, the Ohio Supreme Court has never required physical injury for survivorship. It's always been injury to the person. And Black's Dictionary, this is according to the Sixth Circuit case Krabs v. Scott, they quote Black's as saying, that is an invasion of personal right, including mental suffering. So keeping that phrase personal rights in mind, you turn to the Witcher case from this district, and the important quote in that case is, in order for an action to survive, the action must be for injuries to the person, and that term means physical injuries. And the tort involves injury to the plaintiff's personal rights and thus does not survive. But the cases quoted actually, it's Oakwood v. McCarr and Joyce v. Columbus, do not say that. Oakwood is about slander and doesn't even discuss the issue. Joyce is a case from 1936 and doesn't even talk about physical injuries. It's a case about a nuisance claim. So somewhere along the lines, that phrase has been used over and over in cases, and it's leading astray on this issue.
Counsel, I'm sorry to interrupt, but I want to let you know that you're moving into your rebuttal time.
Okay, I will finish my thought in the next 30 seconds and just have 2 minutes. That phrase personal rights that was used in Witcher, when you look back to that common law history I was talking about, is talking about emotional distress. And that's exactly what was envisioned, and that's the precursor to what this statute is in this case. So actually the common law did allow these types of claims to survive, because emotional distress claims and breach of contract claims did survive death at common law. Thank you.
Thank you. You may go.
Good afternoon, Your Honors. If it may please the court and my fellow colleague, I'm here on behalf of the state of Ohio. I understand that what Ms. Berry has said, that this is a case about the legacy of Mr. Jones. I disagree. This is a case about whether the court had jurisdiction to do what it did when it entered the declaration of wrongful imprisonment, and whether the two parties that were parties to this lawsuit had authority to go forward and pursuing that declaration of wrongful imprisonment once Mr. Jones passed. The revised code 2305.21 governs the survival of actions. And essentially the only actions that survive, which is not this action, are actions that survived at common law actions that continue today, and other actions that where someone, a plaintiff, can be compensated for injury to person or property. Now, the estate wants to conflate 274348, the two steps, into one, and say that this is all one process that the common pleas court could do, and grant some universal settlement. And that's not what the common pleas court can do in this case, in this situation. The General Assembly has purposely created language in 2743.48 that creates a two-step process. The common pleas court can only make a declaration of whether someone was wrongfully imprisoned or not. It cannot award money. It can't enforce a settlement about money. That is all up to the jurisdiction of the Court of Claims. That's the second part of that statute. All of the instances where the estate has cited, where it references the term person in 2743.48, those often refer to the second part of the process of obtaining a monetary.
So counsel, just to go back to your earlier point.
Sure.
So is it then impossible to have a global settlement with both the first part that is within the jurisdiction of the common pleas court and a money amount, or is that?
I don't believe that you can have a global settlement, and you can reach towards that global settlement. You can.
Is that what was happening here then?
I believe the parties were in a process to enter a settlement, but it's wrong to say that this case was settled in January of that year that Mr. Jones passed away.
So the court, so they were, what would have been required? Obviously the appellant says there was a settlement. What would have been required had Mr. Jones not passed?
What would have been required and what was starting the process by the two counsel at the time was coming to terms for this declaration of wrongful imprisonment. And after Mr. Jones passed away, or prior to that time in January, when the court entered that entry, there was no terms agreed to for that declaration of wrongful imprisonment. That declaration guides what the Court of Claims does in terms of paying out the money. There are specific terms that guide how much it pays, and under the statutory formulation.
So counsel, there was no declaration of innocence that was in effect and then rescinded?
I'm sorry?
There was nothing that was put in place and then rescinded?
No.
Well, counsel, aren't we here on an appeal from the trial court issuing a 60B5 motion to
Yes.
vacate a prior order? So then how can we not have an order that's been rescinded?
Well, we do have an order that was rescinded. I believe that you were talking about January 30th at that time, when the court entered its entry. It entered an entry. When trial courts often learn that a settlement may come into place, they often put like a settlement entry or a settlement notice entry to follow that contains like maybe the terms of the settlement and such.
So,
The parties were on a course to.
hold on one second,
Okay.
to follow up, unless of course, because
You go ahead.
it's my understanding the state filed a motion under 60B4 and 60B5 to vacate the trial court's entry.
The declaration of wrongful imprisonment.
Right. And then the trial court found that it needed to be vacated under 60B5.
Yes.
Any other reason?
The other reason, it was also a joint motion in addition to 60B5. It was also a motion to vacate simply because that declaration of wrongful imprisonment is a void and null judgment. And the trial court has authority to vacate void and void.
So I'm in agreement, because the trial court, not with the conclusion, but with what the trial court's orders does. It says,
Correct.
under 60B5, I did not have jurisdiction to do that.
Correct.
I know why there are a lot of arguments about equities, but that's 60B4.
Mhm.
Okay, that's no longer equitable. I don't know the specifics of the arguments on jurisdiction as it relates to what the trial court found, because the paragraph that precedes that says, I don't have jurisdiction to do anything about the Court of Claims monetary award,
Correct.
which is different than I don't have jurisdiction to enter the declaration of innocence those are two different orders we're talking about, and that's how it got meshed, I think, right? So what tells the trial court they don't have jurisdiction to enter into the declaration of the order that was vacated?
What tells that it doesn't have jurisdiction to do that is 2305.20.
Which just says that it needs to be commenced by an individual who suffered all these things as an individual.
Correct.
And isn't that true?
Right, and so there's not a proper party in place. And so what should have happened was, once Mr. Jones passed, there should have been a notice of suggestion of death by either party, and it didn't happen. And there should have been a motion to substitute a proper plaintiff, so when there's not a party at all, a court can't even enter into a judgment, simply because if it did so, it's null and void, because there's no one to put it into effect to or against. And so that's why the court didn't have jurisdiction to pursue the declaration of wrongful imprisonment at that time. There's no party.
Is that your understanding of what the court found in its entry?
My understanding of what the court found in its entry is that it just simply did not have jurisdiction to enter into the declaration of wrongful imprisonment because, one, there was no party, and two, this is a statutory created action that abates upon someone's death. And unfortunately, Mr. Jones passed away. And, we talk about these cases, where Mouse and Morgan, and the cases brought up by the estate. Those two cases are simply cases against private parties. They're not against the state. That's why they're inapplicable to this action. You can't make a comparison or analogy to them. The police in Morgan were acting on behalf of B.F. Goodrich down the street here. They weren't acting on behalf of the state of Ohio or the city. The Witcher case concerns a false imprisonment claim. That's a tort claim. That's not a statutorily created claim like this wrongful imprisonment action or process under 2743.48.
Is the wrongful imprisonment statute creating a right, or is it waiving immunity only?
I think it is a little both. It's a creating a right, and the fact that, it's allowing someone to be declared wrongfully imprisoned. It's waiving immunity in terms of that someone can sue the state and be compensated for that amount. I'm coming close to my end here. We talk about the legacy of Mr. Jones and such, and, you know, this is no different from like a divorce action when it abates. And I'm sure the court is familiar with, you know, divorce actions. When two people are attempting to divorce and one of them passes away, the action abates. And there are times, you know, where someone may say, you know, I think we've come to an agreement as to, you know, how to resolve this divorce and, you know, sell the assets and, you know, split them up. And if those terms are not read into the record, then it doesn't exist. It abates. But once those terms are read into the record, or there is a final judgment, a final divorce decree, then that's enforceable. And I would refer the court to State Ex Rel. Liddy versus Leskoviansky, it's 77 Ohio State 3rd, 97. And this is no different from that. You know, it's improper for the appellant or the estate to say that this was settled. If it was settled, there would have been a payment. There would have been a signed agreement, signed settlement agreement, and in addition to a mutual agreement of terms. There wasn't a mutual agreement of terms to the declaration of wrongful imprisonment, and there's nothing on the record that shows that there was an agreement to terms to a settlement agreement. And it certainly wasn't authorized by our office. And, you know, this is where it goes to, you know, the authority of the parties to enter this. I have no doubt that Mr. Madden and Ms. Berry intended to have good intentions to, you know, preserve Mr. Jones's legacy and such. But you can only do so when you have the authority to do that. And the court can only do so when it has jurisdiction to do that.
What was Mr. Madden's role with the office?
Mr. Madden's role was, he was a senior assistant attorney general in my section, and, you know, he litigates these matters, and then in order for them, for any matter for the state of Ohio to be signed off on, it has to go up the chain. And basically,
But was it signed? Was it signed off on? Did Mr. Madden sign?
it was not signed off on.
Did Mr. Madden sign something?
Mr. Madden may have agreed and signed the declaration of wrongful imprisonment when
Okay.
it was submitted.
And
But what,
and I'm still a little bit confused.
Sure.
So was the declaration of innocence, was that actually adopted? Was that agreed to, put in place? What was the status of that?
the status of that as of Mr. Jones's death?
No, before Mr. Jones's death.
Before Mr. Jones's death, it didn't exist.
Okay.
It didn't exist. And so that's why there's not a final settlement in this case. There was an attempt to get there, but they just didn't get there. And, you know, I understand the good intentions of the parties and the council at the time. And, you know, unfortunately, my office and the Attorney General has a duty to follow the law, just as the court has a duty to follow its jurisdictional authority. And that's why the court did what it did when it vacated the declaration of wrongful imprisonment, when it learned that Mr. Jones had passed prior to its issuance. It learned that it was a null and void judgment. The issue, the complaint should really be directed at the General Assembly. The language of 2743.48 could be changed or amended to consider these types of scenarios and address them, but it simply doesn't. And so that is why we are here where we are today.
Thank you, counsel. Your time's
Thank you.
up. You got just a little over 2 minutes.
Thank you. Your Honors, I'm very troubled by what the state just presented to you, because the facts, and I'm not saying this was intentional, but I believe he knows differently, the facts he was stating to you are simply wrong, and the correct facts are in the record, in the affidavits, and in the attached emails, so you can see what actually happened. There was a settlement that occurred. This type of thing happens in these wrongful conviction cases all the time, where there is a global settlement for all the terms, and then it's up to each individual court to enforce their part of it. There was an agreement that there was a declaration of innocence. He's coming up and saying there was no agreement for that. It's in writing. Now, true, the court signed the declaration of
So
innocence.
what stops you, if there's an actual contract settlement with a monetary amount and a stipulation that he would get that certificate, what stops you from going to the Court of Claims and enforcing that settlement as a contract, like that it's a settlement? Because, you've already bargained that they made a full global settlement.
We actually attempted to do that, and we have an appeal that's being held in abeyance in the 10th District over exactly that, because the Court of Claims dismissed our complaint, saying that once the Declaration of Innocence was rescinded, they didn't have jurisdiction because that Declaration of Innocence is the ticket into the Court of Claims, so that was necessary. But I have a big problem with the state coming up here and saying there was no settlement when there was. And what the court's January 20th entry, the trial court's January 20th entry says, this case is settled and dismissed, and if the parties don't enter additional terms within 30 days, then this January 20th entry is the final entry. Now, had I not been collegial, I could have just filed something because the state was being non-responsive, and maybe I should have not been so professional and done that, but I asked for continuances on behalf of the state to try to get them to be, part of that process. Ultimately, the court had to hold an additional status conference to see why the state was unresponsive. But the terms of the settlement for a declaration of innocence and for a specific monetary amount occurred prior to Mr. Jones' death. Now, one thing that's very important is, even if we hadn't come to a specific agreement on the monetary term, that really isn't relevant. Frankly, once there's an agreement for the Declaration of Innocence, and that's all that's needed, that's all the evidence that's needed to get into the Court of Claims, that triggers a process that says there's a specific monetary amount that this plaintiff will get paid for each year of wrongful imprisonment, and also within 60 days of that Declaration of Innocence being entered in the common pleas court. No questions asked. It says shall. That shall be paid. So we came to the term that we did for reasons, that are not really relevant today. But even if we hadn't, the Declaration.
I'm going to have to ask to wrap up.
Thank you. Even if we hadn't come to that term, the agreement for the fact of the Declaration of Innocence was all that was needed, and that clearly occurred prior to Mr. Jones' death. Those terms were presented to the court, and that's why the court entered it as settled, and you can see the terms of that in writing prior to his death.
Thank you.
Thank you.
Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it's released, and it will also be posted on the Ohio Supreme Court website. This court is now adjourned